This is the Cobb County Family Law Workshop presented by the Cobb County Superior Court in conjunction with the Cobb County Bar Association, including the Family Law Section and the Younger Lawyers Divisions of the Cobb County Bar Association. Today we're going to talk about the basics of filing and prosecuting or defending a family law action. We will cover it in 4 steps. First, the basic anatomy of filing a lawsuit. Second, the basics of divorce, both including children and without children, modifications, and contempts. We'll start with the basics of the anatomy of filing a lawsuit. There are 5 basic parts of filing a lawsuit: the filing of the lawsuit itself, service of the lawsuit upon the party being sued, that party's response to the lawsuit, a hearing where a judge hears all the evidence and makes a determination based upon the evidence presented at the hearing, and the judge's final order, which adjudicates or renders a final decision in the case. The first thing you have to know in filing a family law lawsuit is what to file. Well, the first thing you need to know is what kind of case you have, and we'll talk about that a little more as we go along through the presentation and get into the basics of divorces, modifications, and contempts, as well as legitimations. But the first thing you need to know after you know what kind of case you have is in which county you should file the case. In Georgia, the basic rule is that you file your case in the county in which the person who you're suing resides, and we'll talk about that more specifically here in a minute. You also, after you figure out what kind of case you have and where you're going to file the case, you need to know how much money it's going to cost to do so. Unfortunately, filing a lawsuit isn't free. While the expense is it's relatively inexpensive, it still costs money, and you have to determine how much you have to pay to file your lawsuit and to have it served. You need 3 things when you file your lawsuit. The first is a summons, which is a direction to the sheriff to serve your lawsuit upon the party being sued, the petition itself, which is the actual lawsuit, and then your fees or a waiver of those fees as allowed in certain circumstances. Well, after you figure out what kind of case you have, you need to figure out where to file it. And as we talked about earlier, you always file your case in the county where the defendant resides, with few exceptions. The legal term for this is venue. It literally means where the person who you're suing resides, or where the case will be heard. As I said, generally speaking, you will file your case in the county where the person who you're suing resides. For instance, if you're filing a divorce suit and your husband lives in Cobb County and you're seeking to divorce him, then you'll need to file the divorce petition here in Cobb County. If he lives in Cherokee County, then you'll have to file it in Cherokee County. You always want to know where the person you're suing resides so that you can file your lawsuit there, because that's where venue will almost always be proper. As with most rules in the law, there are exceptions, and there are a few exceptions to this rule. The first, most common exception is if you're filing a petition for divorce and your spouse has moved away from the county where you lived as husband and wife, you can still file for divorce in that county for up to 6 months after you last lived as husband and wife. If, however, more than 6 months has lapsed since you last lived as husband and wife, and when you're filing the lawsuit, then you have to file in the county where the person you're suing resides. There's another exception involving situations where your spouse or the person you're suing lived in Georgia but no longer lives here. If your spouse now lives in another state, there are special exceptions that allow you to sue them other than in the county where he or she resides in that other state. But that requires a lot of special procedure and will require you most likely to hire an attorney, which we'll talk about at the end. All right, so at this point we've decided what kind of case we have. We've decided where we're going to file it. The next thing you have to do is have the lawsuit served upon the party you're suing. You can never sue somebody and proceed to a hearing and get an order without actually serving them with the lawsuit and allowing them the opportunity to defend themselves. So service is an essential part of every lawsuit. It literally is the formal notification to the other side of your filing of the lawsuit. There are 3 particular kinds of service. Personal service, which is where the lawsuit is actually handed to the person being sued. There's service by acknowledgement, where the party being served acknowledges that they received it without it actually having to be placed in their hands through a formal process. And then there's service by publication. What you need to keep in mind about service is that the most common and most often used form is personal service, where the lawsuit is actually handed to the party being sued by the sheriff or a private process server. The reason that you need to keep that in mind is it is only with few exceptions that will be the type of service that you use. Thankfully, however, the sheriff or a marshal in certain circumstances will actually serve the lawsuit for you in exchange for the fee that you pay in conjunction with filing of the lawsuit. Always keep in mind that service is absolutely required in order for you to proceed with your lawsuit. You will never get the opportunity to go to court, have your case heard, and have a judge rule upon it unless you can show that you have served the other party or that you have made diligent efforts to have them served. So at this point, we've figured out what kind of case we have. We've filed it in the proper venue. We've had it served upon the other party. The next step in prosecuting your lawsuit is the other party's response. And this may actually apply to some of you watching this video who have been served and are trying to respond and to defend your case. Always keep in mind that a party being sued has 30 days to respond to the lawsuit. That's 30 calendar days, including holidays and including weekends, from the date that the complaint or the petition is placed in their hands. The one thing to keep in mind that often comes up in these situations is, well, do I need to file a response? The answer is yes. You always have to file a response unless the case is uncontested. Just keep in mind that a case is only uncontested if both parties agree upon everything. That means there is nothing they do not agree upon. And in those situations, even then, there also is a response filed. It's just not necessarily in the form of an answer. But if a case is contested in any way, shape, or form, then the party being sued has to file a response within 30 days. If you don't file that response, then you run the risk of having everything in the lawsuit admitted and the party seeking the recovery or the party filing the lawsuit getting everything that they asked for. So you can see why it's so important to respond to a lawsuit within the 30 days. So at this point, we're now moving along in the lawsuit process. We've determined what kind of case we have. We've filed that case in the proper venue. We've had it served. The other party has responded. And so now you proceed to the point of the lawsuit where you actually go to court and have your case heard. You present evidence that the judge uses to rule upon, to issue a ruling in your case. There's two types of hearings. There are temporary hearings, and then there are final hearings. The only thing you need to know about the difference between these two is that a temporary hearing only applies if you're trying to address custody, child support, or visitation while the case is pending. If none of those three things are at issue in your case, then you'll never have to deal with a temporary hearing. And it's only if one of those three things or any combination of them are at issue that you'll have a temporary hearing. Otherwise, the only hearing you'll have in your case is a final hearing. Keep in mind that the final hearing is where you're coming to court and you're presenting your evidence. You're presenting everything that you need to present to support your allegations or what you are seeking to recover as part of the lawsuit. It is where you'll come into court, present witnesses, present documentary evidence, and where the judge will hear all of the arguments and all the information you have and make a ruling on your case. It's therefore important to make sure you have everything in order by the time that you get to the point of a final hearing. You need to make sure that you have all your evidence, you have all your witnesses there, and you're ready to show the judge whatever the judge needs to see in order to issue a ruling on your case. It's as a result of this hearing that the judge is going to issue your final order, and it is probably the most important day of any during the lawsuit. Keep in mind that with regard to a hearing, you have to schedule it. Keep in mind that you can only do this after the other party has been served with the lawsuit and has been provided an opportunity to respond and has either responded or the time for them to respond has lapsed. You need to call the court clerk after the 30 days from service has passed and schedule your hearing at that point. Keep in mind that unlike you see on TV, there's no such thing as trial by ambush. Every side is entitled to an opportunity to be in court and have their side of the case heard. So you can't proceed to a hearing unless you also let the other side know about the court date. This doesn't have to be done formally through service like it does with the lawsuit, but you do have to send some form of notification to the other side to let them know about the hearing date and about their opportunity to be there and present their side of the case. It's important, although it doesn't have to be done through a formal means like service of a lawsuit, that you be able to show the judge that you've notified the other side of their opportunity to come to court and be a participant in the hearing. Most often this is done by showing that you served notice via certified mail, UPS, or FedEx. Some way, you served it in some way or you gave them notice in some way that you can prove to the judge that you did so. Because the judge isn't going to let you proceed with your case and proceed with the hearing unless you can show that the other party was given the opportunity, was notified about the hearing, and given the opportunity to be there. Again, remember, if you have documents or witnesses or any other information that you need to present to the judge to help the judge rule on your case, bring it with you to the final hearing. And always, always, always bring with you a proposed final order to the hearing. Remember, it's after the hearing that the judge is going to issue the order that in which he or she sets forth the ruling on your case and makes his or her determination. So it makes sense to have a proposed order with you when you come to court. That way the judge has it there with him in court that day and sometimes can sign it there in court, and your case can be heard and determined at the same time. We're now going to move on to the substantive portions of the presentation dealing with divorce, legitimation, modification, and contempt. And I'll be back soon to talk to you about contempt and some additional issues related in general to lawsuits.
Now we're going to talk about some of the substantive areas of family law in which you might be filing a lawsuit in Superior Court. Now, most of you who are watching this video or attending the workshop are probably here seeking help with filing for divorce. Everybody knows what divorce is. Divorce is the permanent end to a marriage, and a court has to issue the order of divorce. It determines how property and debt are divided and determines how to handle the issue of any children of the marriage. And either party can file. Now, divorce in Georgia by itself is not complicated. It's a no-fault state. If one party wants to get divorced, you're getting divorced. Where it gets complicated is dividing up the things and the property and the money, and most importantly, how to co-parent the children once a marriage ends. And that's when divorce gets complicated. And that's why it is very important that you know what you're doing if you intend to try to get divorced on your own. Either party can file, which means it doesn't matter who gets to the courthouse first. There is a plaintiff and a defendant, but you're both after the same thing. And there's no offense and no defense. It doesn't matter who files first. But to get started, you do have to file. My predecessor talked a little bit about where you file and how you file. Now we're going to talk about what you file. First, if you're filing on your own, you need to know which forms you're going to need. There are two main kinds of sets of forms for divorce. One for divorce with children and one for divorce without children. You'd be surprised to hear that a lot of people aren't sure which form they need. Now, I have children, and I will tell you that I noticed that they live in the house, so one would think you would know, but it can be a little complicated. You do need the divorce form with children if you and your spouse have children together, regardless of when they were born, and those children, none of those children has yet reached the age of 18. So if you have minor children with your spouse, regardless of when they were born, you need the form for divorce with children. If you and your spouse have no children together, even if you have children with other people, or all of your children are 18 or over, you can do the divorce form without children. As with all of these forms, you need to complete them in their entirety. Do not leave anything out. Every question and paragraph is there for a reason, and if you omit it, it could impact your case. You need to sign the form, and you will need to sign the verification attached in the packet in front of a notary public. There are notaries available at the courthouse, at banks, law offices. You have to do this for every family law case. Georgia law requires that all family law pleadings be verified, meaning that you complete the verification. That states that all of the information that you provide in your form is true and correct to the best of your knowledge. Be sure you follow the instructions in the packet. If you do not understand them, please seek a lawyer's advice. The clerks are not going to be able to provide you advice. And keep in mind that all of the forms in the packet don't necessarily get filed all at once. So be sure you understand what you're signing. So beyond the forms, there are several special requirements in divorce that don't exist in other kinds of lawsuits. Some are statewide rules, some are local, but these are the rules as they apply here in Cobb County. First of all, if you are getting divorced and you have minor children with your spouse, you have to take the Divorcing Parents Seminar. It is offered through the ADR Office of Superior Court. It is for a nominal fee, and it's a very short class, but you absolutely have to take it and get the certificate Otherwise, the judge will not allow you to get divorced. You have to complete a parenting plan. There's a form for this as well. I encourage you, if you can, to sit down with your spouse and do the parenting plan together. The parenting plan is most effective if both parties agree to its contents. How visitation will work. How will it work co-parenting in terms of religion and schooling? It's all very important to the well-being of your children, and I encourage you to do it together. However, if your spouse is absent or if you are a victim of domestic violence, you can go ahead and complete the plan on your own and submit it to the judge as your proposed plan, and the judge or the mediator can help you work out how the plan's going to be incorporated into the order. Finally, for any case involving children, whether it's a divorce or any of the other cases we're going to discuss, you must complete a child support worksheet. Again, if you can do it with the other party, that's great. If you do it on your own, that's fine too. The form is available at the website in the PowerPoint presentation. You can either download the Excel spreadsheet or you can do it online. If you're savvy about Microsoft Excel, it's very easy to fill out the spreadsheet and print it out yourself. If you're not familiar with the software, I encourage you to use the online version. They both have the same result. The worksheet has mathematical formulas that are promulgated by statute that determines, based on each party's income and the expenses concerning the children, how much child support will be for the non-custodial parent. There's an optional seminar in addition to the parenting seminar for school-age children called What About Me? I would encourage you to consider that, counseling through one of the many nonprofits in the area or a private counselor for your children. Judges appreciate when you put your children first in your divorce, and the children appreciate it as well. Finally, for all divorces, regardless of whether you have children, you must complete a financial affidavit. Any divorce where there's anything to divide, even if it's a set of dishes or a 20-year-old car, you have to do a financial affidavit. There's a form for that. It's about 7 or 8 pages long. You need to be complete. As the prior speaker said, there is no trial by ambush. The judge needs all of your financial information, all of your income, and all of your expenses, and to omit information is to do so at your peril. You need to be very upfront about the money situation because that's how judges make decisions about your case. Finally, most judges in this circuit are going to make you go to mediation. Mediation is a voluntary process in which both parties sit down with a neutral and try to work out the issues in their case. It is the best way to resolve your divorce. It is far better than having a trial in front of a judge or jury determining what's going to happen with your family. The judge can require you to go, and most judges do, before you can have any hearing in your divorce. You'll get notice in the mail that mediation has been ordered, and you'll have an opportunity to select a mediator. If you do not select one, one will be selected for you. There are fees that are the responsibility of the litigants. If you cannot afford the fees, you can apply for a poverty waiver if you are very low income. So let's talk a little bit about the forms. The first is the complaint for divorce with minor children. And again, this applies if you and your spouse have children together. If you have children with other people, but not this spouse, you don't need this form. Those children should also all be minors. If you have any minor children, if all of your children are adults but one, you still need the divorce with minor children form. And even if the children were born before you were married, they are children of the marriage. Even if the children were born in 2000 and you were married in 2005, they are still children of the marriage and you still need this form. Do not use the without children form if you have children. It will cause major problems for you and your spouse and your children now and or later. Read the form entirely. Make sure you fill it out completely. Include the information about the children. You may use initials or abbreviations for children's names for confidentiality purposes. You should not include Social Security numbers or any other confidential information. The point is to address to the court what is relevant in the case and what children you have and what property you have. But again, you do not have to include full names of children. Initials and birth dates are fine. And do not, under any circumstances, include Social Security numbers because this is a public record. And be sure you complete the forms in their entirety and that if you handwrite them, that they're legible. If all of your children have grown or you never had children with this spouse, you can complete the form for divorce without minor children. You still have to do a financial affidavit and you still have to go to mediation, but you do not need a child support worksheet or any of the other requirements regarding children. But again, complete the form in its entirety, don't skip anything. Even if you have no property, you still need to address the question of marital property and state that there is none. Keep in mind, any property acquired during the marriage may be marital property, so don't assume simply because something is in your name you shouldn't include it. This is an area where you should certainly get legal advice. If you omit any property, you may very well find yourself losing that property inadvertently, so get a lawyer to advise you about this matter. The other speaker talked a little bit about the concept of an uncontested divorce. A lot of people think they have an uncontested divorce simply because nobody is fighting today. That is not an uncontested divorce. An uncontested divorce is a case where you and your spouse have reached a complete and comprehensive and signed settlement agreement. You've agreed to all the issues, you've reduced it to writing, you've both signed it in front of a notary public, you've completed all the other requirements for divorce, the workshop, the worksheet, anything like that, and you're going to a final hearing ready for the judge to sign it. That's an uncontested divorce. If you have not completed, reduced to writing, and signed in front of a notary a complete and comprehensive settlement agreement, you have a contested divorce. The settlement agreement, there is a form for it, but keep in mind that this is your settlement, and no two settlement agreements are going to look the same, and they're not going to have the same contents. However, they all have the same elements in that they have to address every single item in the marriage and every single child of the marriage. If you omit it, it is at your peril. Address all issues, even if it is to say, we've already agreed on this issue. For example, if you've already divided all property, you could say something like, we've already divided all property. But you need to reduce it to writing. And again, it is best to have an attorney review your settlement agreement before you sign it. Once you've agreed on the settlement agreement and signed it, it does not become your divorce decree until you present it to a judge and the judge has accepted it and approved it, and it becomes incorporated into a final judgment and decree. The final judgment and decree must accompany the settlement agreement, otherwise you're not divorced. So the final order is the document that the judge signs to make you divorced, or in any case, to make the court case over. If you have a settlement agreement, your final judgment and decree will be about 2 pages long, simply incorporating the terms of the settlement agreement into your final order and making it the order of the court. If you do not have a settlement agreement and you have to go to a trial and have a judge determine the terms of your divorce, your final order is going to be much longer, and it is going to address all of the issues of your divorce, such as property division, debt division, custody of the children, and so forth. You must bring your final order to court with you. As the other speaker mentioned, the judge is going to expect you to have that order with you. The judge does not complete the paperwork for you. You are expected to be prepared with that order, which is one of the many reasons that we encourage you to hire an attorney to help you complete that process. One last thing on the final order that I'll mention, if you have a settlement agreement and you are changing your name and you want your maiden name back, I would encourage you to put that information in your final judgment and decree so that you can get a certified copy of that and easily accomplish the name change without having to present your 20-page confidential settlement agreement to the DMV. The next topic we'll talk about is modification. A modification simply means a change. It is a court case by which a court may change a prior order. Typically, a final order is final, including in family law cases, except with few exceptions. Child custody, support, visitation, and in some instances, alimony. I'll briefly touch on alimony just to say we're not going to really talk about it today. Alimony is a dying breed in Georgia and in many states. There are some cases where alimony is still appropriate, but it's increasingly temporary, and the days of a spouse expecting long-term financial support that doesn't have anything to do with children, those days are rapidly dwindling. So we're not going to talk about alimony. If you have questions about alimony, you should retain an attorney. All that to say, alimony can be modified, but we're going to talk about modification of child custody, support, and visitation. To file a modification, you must show a substantial change in circumstances, and you can only modify once every 2 years. So what does that mean? A substantial change in circumstances is a change that is more than minimal. So an example, parties reach a settlement agreement in a divorce. In the settlement agreement, they agree to joint custody and equal time sharing with the children. Kids spend 1 week with mom and 1 week with dad. Dad moves to New York. Clearly, the 1 week on and off is not going to work unless someone wants to pay for weekly airfare for the children. So you probably need to file a modification. Under the best case scenario, the parties would agree to the terms of the new visitation order, present it to the judge as a new settlement agreement, and do it that way. The other example of a substantial change would be the non-custodial parent losing his or her job. The parent was making $100,000 at the time of the divorce, loses his or her job, and now wants to modify downward his or her child support. And you can do that through a modification action. There are 2 big rules. First of all, you can modify at any point after the final order as long as you have a substantial change. But once you've modified once, you can only modify every 2 years. And courts discourage you from coming back every 2 years like clockwork. They want you to work it out on your own. They do not want you clogging the court system with lots of requests. Try to save your modifications for when you really need it. That said, modifying child support is the single biggest modification that we see. And it's very important for 2 reasons. One, sometimes the custodial parent will find out that the non-custodial parent has substantially more resources, or the custodial parent has substantially less resources and wants to change the child support to make it higher. More commonly, we see non-custodial parents losing their jobs and not able to get a new job, and they want to modify their child support downward. You have to show a substantial change in financial services, and the new child support will be based on yours and the other party's income. The big thing to know, if you are a parent who's fallen behind on child support obligations, you cannot modify backwards. If you've lost your job, you should modify as soon as possible, typically, because you can't fix any of the arrears that you accrue up until the date of that first hearing. So it's in your best interest to change that as soon as possible. You can change it going forward. The other thing to think about when you think you want to change your child support, go ahead and download that child support worksheet off the website and put in the numbers. Put in your income, what you think the other party's income is, what you think the child care expenses are, and see what the numbers turn out to be. Use that as your guide to decide whether filing a modification, which, as we've discussed, costs money and time. Make sure that's what you really want to do first. But again, on the other hand, if you're behind on your child support payments, the sooner you modify, the sooner you can reduce the chances of future arrears. So there's a petition for modification of child support. One thing that I will note is I see a lot of folks using that document to establish an initial child support order, and that's not appropriate. If you need additional child support, there's a separate form we'll talk about in a moment. This petition is for if you want to change an existing order. If you need child support and you want to file an original petition, you have 2 choices. You can do it on your own in Superior Court. We're not going to talk about that today, although there is a form for it. Or you can go through the Office of Child Support Enforcement, and they can help you do it. Now, it takes longer that way. There's a small fee. However, the office handles it for you. You have to participate, but you get a lot of help from the State Office of Child Support Enforcement, and they also help with enforcing it after they've gotten the order. So it's recommended if you don't have an attorney to go through the Office of Child Support Enforcement. Keep in mind there are 2 offices, one if your spouse lives here, one if they live elsewhere, and that information is in the PowerPoint behind me. We're going to talk about legitimation. Georgia is a little behind the times in terms of its rules on legitimation. It is a dying breed of states that still thinks of this term of legitimation. And I say that because if you've moved here from another state, you're probably shocked to find out that we still have that rule here in Georgia. So compared to other states, Georgia's still got this rule of illegitimate children. Now, as offensive as that term might be, it really applies to the dads more than it does the children. The negative impact of out-of-wedlock children is mostly that, in terms of legal and financial ramifications, is that that child cannot inherit from the dad and is not a legal heir, which can be a problem if the father dies and leaves benefits or money. But for the dad, it has profound consequences in that simply fathering a child does not give you parental rights to that child. In fact, simply being obligated to pay support for a child does not give you rights to that child. To have rights to co-parent your child with his or her mother, you have to legitimate, and there are three ways to do that. We'll talk about that in a minute. There's three main ways to do that. First is you can acknowledge legitimation via petition at the hospital. That is only available for children born after January 1st, 2005. You can file a petition for legitimation in Superior Court, which is the most common. And note that if you marry the mother after the child is born, that legitimates the child. The child becomes the child of a marriage and is no longer considered out of wedlock. So those are the three ways to legitimate a child. You still have to pay child support even if you do not legitimate, and only dads can file for legitimation. Mothers cannot. The last thing to note is legitimation is different from a petition for paternity, which simply determines who is the biological father of a child. So Form 6 is a legitimation form. It's appropriate if you are a father, dads only, if you were never married to the mother, and your child was born before, or your child was born in a time when you couldn't have legitimated out of the hospital. Keep in mind that if you filled out the form at the hospital and you don't have it, or if you're not sure you filled it out, you may end up back in court anyway because the hospital doesn't keep those records. And we're going to talk a little bit about the other things you can get in legitimation that you won't get through the hospital form. So all the hospital form does is give you parental rights. You're the legal dad. The child can inherit and you get some rights, but the mom's still the custodial parent. If you want to actually co-parent that child, have designated visitation hours, or if you're a dad raising a child on your own and you want legal custody, you have to file a legitimation petition. The good news is you can petition for custody, joint custody, visitation, all of those things in the context of your legitimation petition. You can do it with the form. I would encourage you to get legal advice about that, but it is something you can do in the same lawsuit, and judges encourage you to handle those things all at once. And keep in mind that any family law case involving children, including legitimation, modification, are all going to require a child support worksheet. And keep in mind that you will need this in order to reach any kind of adjudication in your case. Before the judge will even let you walk in the door to the courthouse, you have to have the child support worksheet. And you need the supporting documents, both for this and your financial affidavit. Prove where the money is coming from, because if your case is even a little bit hotly contested, you're going to need to prove what your income is, because you're the only person with that information. So be sure that you have the documents you need before you show up for your hearing, most specifically the worksheet. Those are just a few of the many kinds of solutions for family law cases that Superior Court offers. Those are the most popular and the most common. Every case is different, and in family law, these are the most important things and people in your life. I encourage you to have an attorney review your case with you and not go it alone, especially when you're concerning your kids, your property, and the family that you've built. Keep in mind that this is all information, and really the advice is so specified depending on your case. The last type of topic that we'll talk about is contempt, and for that I'll turn to our other speaker.
The last of the four types of family law cases that we're going to discuss today is contempt. Contempt is probably the least likely to occur and the one that you are least likely to know about, but it is one you should know about nonetheless. Contempt simply is an action you bring when someone was ordered to do something that they have not done. And you bring a contempt action in order to see that they do what they are supposed to do pursuant to that order. For example, if someone was supposed to pay child support pursuant to an order issued in a divorce case, but is not paying that child support, then you would bring a contempt action to hold them in contempt of that order and seek to have them forced to do what the original order required them to do. So where do you file a contempt action? Earlier you heard me say that you file almost every family law action in the county in which the person you're suing resides. Contempt is an exception to this rule. You file a contempt action in the court where the original order was issued, the order that is not being complied with. The reason for this is because that court retains jurisdiction to see that the order it issued is enforced, and that court wants the opportunity to make sure that its order is enforced and is being complied with. For example, if you obtained your divorce, for example, in Cobb County, and it was a Cobb County order of divorce, and the person that you divorced now lives in Cherokee County, you wouldn't file the contempt action in Cherokee County where they live as you normally would. You would actually come back to Cobb County and file it in the court where the original order that is being violated was issued. In Cobb County, there are actually no filing fees for a contempt action, which is also an exception to a rule that I talked about earlier. As you'll recall, I said earlier that you have to pay to file every type of lawsuit. A contempt action is an exception to this, at least in Cobb County. When you go to court for your hearing on your contempt action, keep in mind that you have to be able to prove that the other party has not complied with the order. You have to come into court and be able to show the judge that the person who you have sued in the contempt action has not done what the previous order required them to do, so that the judge can find them in contempt and order them to comply with that order. And also keep in mind, as my dad always said, 2 wrongs don't make a right, that you cannot also be in violation of that order in order to bring a contempt action. In other words, you have to have what we call in the law clean hands, meaning you have to have done everything you were supposed to do pursuant to that order in order to file a contempt action and have the court order the person who's not doing what they're supposed to do pursuant to that order to do so. In the packet of forms that we'll talk about in a minute is a sample petition for citation of contempt. The one thing to keep in mind about this form, other than the general rules, which is to fill it out completely, to write legibly, and so forth, is to make sure that you specify in this form what the other party has or has not done that has brought about the contempt action. For example, if the divorce order in paragraph 7 required the other party to pay X number of dollars in child support every month, and they're not doing so, then you need to point out in the petition for citation of contempt that it is paragraph 7 of that order and attach a copy of that order to the petition that the party is violating, and that is the reason why you have brought this petition for citation of contempt. Also, as I said earlier, be sure to complete the form in its entirety, and if you have been sued for contempt or you have had a petition for citation of contempt filed against you, to be sure to respond to every allegation made by the party who has filed the petition. Now, we've talked about the basics of filing a lawsuit. We've talked about divorce, legitimation, modification, and contempt. If you're watching this video, you are doing so because you have decided to represent yourself in your family law lawsuit. It is your constitutional right to do so, and you're perfectly capable and able to do so, especially with the information that you've obtained in this video. There are some additional resources, however, in addition to this video, that the Superior Court of Cobb County has made available for individuals such as you to help you continue to represent yourself in this case. The first are a set of forms, some of which we've talked about during this presentation, that are available either for free if you print them from the Cobb County Law Library's website, or for a nominal cost if you purchase them from the law library itself. The maximum cost is $15 and includes the packet of all the forms that we've talked about. You can buy forms specific to particular types of cases for less than the $15. The website where you can download these forms and print them for free is listed below me on the screen. Now, as I mentioned earlier, you've decided to represent yourself in your family law lawsuit. After watching this video, you may have concluded that you need a lawyer, or you may have concluded that you can continue to represent yourself. And if you decide to do so, I wish you the best of luck. Keep in mind, however, that there are certain circumstances in which I always recommend that someone hire a lawyer. As Jeff Foxworthy said, you may be a redneck if. Well, this is a list of situations in which you may need a lawyer if. If your case is contested or the other party has a lawyer, I recommend that you seek out a lawyer to represent you in that case. As I always like to say, don't take a knife to a gunfight. If the other party is represented by a lawyer, then it's best that you too have a lawyer or a gun with you when you go to court. I mean that figuratively, not literally. If your case involves a house, a pension, property, or money, anything of substantial value, then I recommend that you hire a lawyer to represent you to ensure that you get your fair share of that house, pension, property, money, or other tangible items. Just as importantly, if not more importantly, if your case involves children, the custody of children, who will be responsible for the children, who will be able to make decisions in the children's lives following the divorce or the other family law action, then I suggest that you hire a lawyer to help you with that case to ensure that your children and your ability to protect your children is protected also. And finally, as I mentioned earlier, if the person that you are suing in your family law action lives outside the state of Georgia, then I recommend that you hire a lawyer to help you with that case because of the issues involved with filing that case and having it served. If you have decided that you need a lawyer to represent you in your case, that you are in over your head, or you just need the expertise of a lawyer, or if your case fits one of the four that I just described, then there are three separate ways that you can seek out and retain a lawyer to represent you. The first is through this program. Through this program, several lawyers in Cobb County have agreed to represent people who have come through this workshop on a limited scope basis for a reduced fee. A list of those attorneys can also be found in the Cobb County Law Library after this video. In exchange for their agreement to represent you in your case, you pay them $100, and that gets you an hour and a half of time with the lawyer to discuss your case with them and have the lawyer do whatever you think he or she needs to do to help you with your case. Keep in mind that this is called limited scope representation, which is exactly what it says. It is representation of you for a limited purpose. If you choose to pursue a lawyer through the limited scope representation list, keep in mind that that $100 is only going to get you an hour and a half of that lawyer's time, and that any additional time and the cost for it will have to be negotiated by you and the lawyer. In addition, keep in mind that you and the lawyer will have to negotiate what the lawyer is going to do for you as part of that representation. If you decide that you want to pursue a lawyer through some other means, I direct you to the Cobb County Bar Association's Lawyer Referral Service, the telephone number for which can be found in the Cobb County Law Library following this video. You can call that number between 9 a.m. and 2 p.m. Monday through Friday and speak to someone in the office at the Cobb County Bar Association who will provide you with the names of attorneys who specialize in the area of law that your case involves. You get for $35, you get a 30-minute consultation with one of these lawyers. Keep in mind, however, that $35 for 30 minutes is a less cost-effective use of your money than an hour and a half for $100. Finally, if you qualify financially, if your earnings are such that you cannot afford a lawyer pursuant to specific special criteria, you may qualify for legal representation through the legal aid of Cobb County. If you call the number that is also available in the Cobb County Law Library for legal aid of Cobb County and speak with one of their intake folks between 9 a.m. and noon, Monday through Thursday, you may realize that you qualify financially for representation through legal aid of Cobb County. Please keep in mind that you can only obtain representation through legal aid of Cobb County if you qualify financially, and it is only those who have the least means financially who generally qualify for that representation. We hope this workshop has been helpful and will assist you in prosecuting your family law action. Best of luck.